So good afternoon and welcome to session W14, today's consideration for tomorrow's regulations, the Atomic Safety and Licensing Board panel session at the 2026 RIC. I am Administrative Judge Jeremy Mercer. At the request of our Chief Judge, Judge Roy Hawkins, to whom we extend a very sincere thank you, my colleagues Administrative Judge Froelich and Bulwark and I are chairing this session. But I would be remiss if I didn't say none of this would have been possible without the tremendous work of the power behind all of us, Ms. Twana Ellis over here to my left. Before we get to the substance, a few preliminaries. If you're attending in person, the Wi-Fi code is RIC 2026, capital R, capital I, capital C, 2026, no space. And just like at the movies or at the theater, this is the obligatory announcement to silence your mobile devices. The session is being video and audio recorded, and we don't want your ringtone to make a cameo appearance. We've planned approximately 30 minutes at the end for questions and discussion, so feel free throughout to submit your questions electronically. Judge Bulwark will be monitoring those and will pose the questions to the panelists at the end after the presentations are concluded. For those of you here in the room, you're going to need to use the QR code, which will be on the screen somewhere at some point in time. You've probably done it already, and there it is. Scan that and it'll bring up the box to submit your questions. If you are attending online, there will be a Q&A box on your screen, either to the right or down below, depending on how your screen is set up. All questions, whether you submit them here in the room or online, go to the same queue, and Judge Bulwark will see them, so no worries there. We also ask that you do submit feedback on the session by scanning the appropriate QR code or clicking the appropriate link. We will consider the feedback as we prepare next year's session, if we're invited to do one. Now to the substance. Our panel today will explore how federal agencies, including the NRC, can navigate through the sometimes rocky shoals shaped by recent and long-standing legislative enactments, judicial decisions, and executive actions as they try to move forward with rescinding old regulations, enforcing and defending new regulations. Most in attendance will be aware of President Trump's Executive Order 14-300, requiring extensive regulatory review and updating or reform here at the NRC. The Commission is in the process of complying with the dictates of that executive order, including, as Commissioner Weaver mentioned in his plenary this morning, the requirement to streamline the public hearing process. The proposed revisions to Part 2, or the hearing procedures, were published in the Federal Register on March 3rd, and comments are due 30 days thereafter. In the regulatory review and reform process, many questions can arise. What level of deference is due to the NRC's interpretation or enforcement of existing or new agency regulations in light of recent judicial decisions? Separate from the concern about transparency mentioned by NRI's Judy Greenwald this morning, what is the impact on deference, if any, of EO 14-215's requirement that OIRA review new significant regulations? Does the demise of Chevron deference portend a demise or cutting back of our deference? How does the requirement of 7-county infrastructure for courts to give agencies deference as it relates to certain NEPA issues play out in light of the Loper Bright decision ending Chevron deference? Does the Atomic Energy Act's specific and judicially recognized, quote, unique, close quote, delegation of responsibilities to the Commission have any impact on the regulatory requirements facing the Commission? Does the recent NRC versus Texas decision or the longstanding Siegel versus AEC decision shed any light? Does the Atomic Energy Act statutory language impact the applicability of a West Virginia versus EPA argument? And in light of the recent arguments in Trump versus Slaughter, what is the future of independent regulatory agencies? I could go on, but I won't. We've asked our panelists to provide us with some insights on these and other issues that the Commission needs to consider as it goes about the process of reviewing and revising its regulations, even as the ground under it is shifting or changing or uncertain in light of the new and impending court decisions. We're also going to hear insight on what the Commission might anticipate in court challenges to those regulations, either to their enactment or to their enforcement. And we're lucky enough to have on our panel a former U.S. Court of Appeals judge who we hope will give us some insights into how an Article III court may approach analyzing or deciding those litigation issues. And with that, my turn at the podium is over, and I turn it over to Judge Froelich, who has the honor of introducing our esteemed panel. Judge Froelich.
Thank you. Our panel today is truly a stellar panel to address the issues that Judge Mercer has laid out. First, we'll hear from Peggy Little. Peggy Little is the Senior Litigation Counsel to the New Civil Liberties Alliance, NCLA. She has over 4 decades of experience as a trial and appellate litigator in complex, high-stakes regulatory, mass tort, class action, products liability, securities, commercial, and civil rights litigation representing individuals and high-profile litigants. Peggy's a graduate of Yale College and Yale Law School, where she was awarded the Potter Stewart Prize. She was a law clerk to the Honorable Ralph Winter of the U.S. Court of Appeals for the Second Circuit. Peggy will be followed by Professor Victoria Norse, who is the Ralph Whitworth Professor of Law at Georgetown University Law Center. Professor Norse is one of the nation's leading scholars of Congress, the separation of powers, and statutory interpretation. She has taught law at several institutions, including Yale, NYU, Northwestern, Emory, and the University of Wisconsin. Professor Norse has published widely on the power of the president and the separation of powers. Professor Norse is also the Vice Chair of the U.S. Commission on Civil Rights. She holds a BA from Stanford and a JD from the University of California, Berkeley. She'll be followed by Andrew Averbach. Many of you know Andrew. He served as the NRC solicitor until November 2025, a position he held since 2012. In 2025, the NRC awarded him a Distinguished Service Award in recognition of his extraordinary contributions to the agency in federal court litigation. Next week, he will begin as a partner on the environmental team of the Business Litigation Practice Group at the law firm Womble Bond Dickinson in Washington, D.C. Prior to his time at the NRC, he served as senior trial counsel at the U.S. Department of Justice. He was in private practice in New York after graduating from Boston University School of Law and clerking for the Honorable Joseph DeClerico, United States District Court for the District of New Hampshire. He is also a graduate of the University of Virginia. Andrew has briefed and argued in the Courts of Appeals in cases where the major questions doctrine has been invoked, and in numerous challenges to the agency's authority to issue licenses for off-site storage of spent fuel. Batting cleanup for us today is the Honorable Thomas I. Vanesky, who has served on the United States Court of Appeals for the Third Circuit for 8 years. Prior to that, he served as a district court judge for the United States District Court for the Middle District of Pennsylvania for 16 years, including 7 years as chief judge. He is currently a member of Stephen and Lee's litigation department and chairs the firm's appellate and mediation, neutral services, and ADR practice. Judge Vanesky received his BA from Lycoming College and his JD from Dickinson School of Law. He was a law clerk for Judge William Nealon Jr. of the United States District Court for the Middle District of Pennsylvania. And now I'll turn it over to our first speaker, Peggy Little.
Good afternoon. I'm very honored to be invited to speak to you today. My assigned task is to talk about maybe 10 or 12 cases from the Supreme Court that apply across administrative agencies. And actually, many of them apply to the SEC because that's just a super busy agency. And so forgive the fact that these landmark decisions seem to be coming up in the financial regulation area, but they do apply across all administrative agencies, and that will be, of course, a topic for us to all discuss today. I am the generalist in the room here, and I hope to learn a great deal as well. I think there is no better time to be practicing constitutional law than in administrative law today. The theme of the various cases I will be talking about, and there are about 10 or so of them, is who does what in our government, separation of powers. And as I say, many of them involve Article 2, which is the executive branch and executive power, and how many constraints can be put on the executive power, as well as how does it need to be able to exert power in order to take care that the laws be faithfully executed. Some involve constitutional rights, and at least one of them is an interesting case about timing. But let me commence with restoring the Constitution and cases involving administrative adjudication, always a topic of concern in agency power. Now, why is administrative adjudication a concern? That's because the agency acts as investigator, prosecutor, judge, jury, penalty assessor, and in most of these schemes, the first court of appeals. Now, early on, many of these administrative in-house adjudications had to do with minor licensing issues, et cetera. But in the SEC world, the Dodd-Frank Act in 2010 extended it to the ability to charge people enormous fines, penalties, lifetime bars from their profession, et cetera, in an in-house administrative court. And that development in Dodd-Frank is what put the tension on what administrative law judges can do. The first case was Lucia versus SEC, and that came up in 2018. Another fact I should mention is by the early part of the 21st century, Americans were 10 times more likely to be charged by an administrative law judge than a judge in an Article 3 court. That should be a topic of concern because the Constitution, at least as I see it, places the judicial power in a separate branch of government. But by early 21st century, administrative adjudication had become the norm, hence the tension. In Lucia in 2018, the Supreme Court held that the SEC administrative law judges who had never been lawfully appointed had to be lawfully appointed. So that was the first incursion into that scheme, and the SEC had to vacate, I think it was about 100 cases, and then they had to go back and be retried. At that point, I represented Ray Lucia, and he had to go back before a still unconstitutional administrative law judge who enjoyed too many layers of removal protections. Shortly after Lucia was decided, there were a cluster of cases, one of Siegel law, the other is Collins versus Yellen, and then Free Enterprise Fund, which was actually an earlier case, also dealt with the removal power. And what the removal power means is, does the president have power to remove the administrative law judge, or are there too many layers of tenure protection that keep that judge in office without presidential control? That cluster of cases, which was roughly 2020 to 2023, recognized that there were unconstitutionally multiple layers of removal protections, although even Collins v. Yellen, which was the latest of them, held that you had to show that having a ALJ who had too many layers of removal protection actually affected your case, which of course is impossible to do after the fact. So the removal question is still open and ripe for review in a context where you don't have the problem of the adjudication having already been finished. Then there was the case of Axon versus Cochran, and that's a really interesting SEC case because what it held was you can go to federal court and challenge removal or other constitutional deficiencies in your administrative adjudication in an Article III federal court. The response to that at the SEC was fascinating. They dismissed all 42 of their open cases, even cases involving serious securities law violations. There was a pretextual reason for that, and that had to do with a scandal where the enforcement staff was accessing administrative law judges' files. But I think the real reason the SEC did that sweeping dismissal of all those cases is that they did not want to risk a Article III court ruling on removal protections and other constitutional issues. So that's a still very active field for us. Now, the next case, which is hugely important, is not so much about separation of powers, although it is also about that, but also jury trial, which is a constitutional right, and that's SEC versus Jurcacy. There are two holdings in Jurcacy. The first is if the federal government is charging you with in an action that will involve monetary penalties, you are entitled to be in an Article III court in the first place. That is quite a change. Also, if your case, like fraud, is of the type that was triable in a jury at the time the Constitution was adopted, then you also have a right to a jury trial. Those are 5 securities law cases, but their holdings do apply across all agencies. I'll talk about deference next. And the big case there, of course, is Loper Bright. And in Loper Bright, the court held that it is the duty of courts to say what the law is, not to accept with greater or lesser amounts of deference the agency's interpretation of what the law is. So again, it puts the judicial power back in the judicial branch. The facts of Loper Bright are really important. These were herring fishermen in the Atlantic who, where there were, the National Oceanic Agency wanted to put observers on their boats having to do with catching fish. Now, the fishermen had no problem with that, but Congress failed to appropriate funds to pay the observers. So rather than take that message on the failure of appropriation and do what is constitutional, NOAA, as the agency is called, charged the fishermen the $700 a day it would cost to have the federal observer on their boat. Loper Bright, in my opinion, was very correctly decided for any number of reasons, but for an agency to assume it has the power to act in absence of appropriations and then to self-legislate and self-tax, this is a mere agency, the very regulated parties that it is regulating, and make them pay for their own regulation is truly a constitutional atrocity that needed changing. Finally, one of the things we will be talking today is presidential control over agency leadership and policies, and of course, we're all waiting to hear from the Supreme Court on that. That might involve the reversal of a case called Humphrey's Executor, which did say the president did not have absolute control over the commissioners in a multi-commissioner agency, and it will be very interesting to see how that case turns out. The betting is that Humphrey's Executor will be overruled, but I certainly don't like calling cases before they get ripe. The next case I'd like to put out before you is called Corner Post. It's a sleeper, just like Axon, in that it's one of these cases that will come to have great effect, probably far more than is realized at the time. Federal statutes and agencies very often put very short statutes of limitations on the time in which you may challenge a regulation. Also, there's usually a 6-year statute on challenging these regulations, and the understanding had been if you've survived the agency statute, which was about 60 days, or got beyond the 6-year period of time to sue, you were home free. The Supreme Court said, no, there is no such thing as what they called, if a federal regulation is unlawful, just because it makes it 6 years without being contested does not mean it enters a promised land free from legal challenge. And the other way to put this is an unlawful regulation does not become lawful through the mere passage of time. So the new rule is if a regulation is unlawful or otherwise violates important rights that are put into the Constitution, you may, your time to sue begins when you're harmed by the agency action. So that what this opens up is a world of challenge to agency power that is not constrained by very short statutes of limitations as it has been for a long time. The final decision I'd like to just bring before you is West Virginia versus EPA. That's called the major questions case. And in that case, the EPA was trying to shut down entire coal-producing plants under a 1970 act that gave it certain control over operations of existing plants. And what the Supreme Court said in the major questions case is the decision to shut down certain types of energy-producing plants is to be made by Congress, not by administrative agency, over interpreting what its power is under old statutes that were never passed conceivably to embrace the power that the agency is claiming. I have, in preparation of this event, studied some interesting cases, Siegel versus the AEC, a 7-county case, and NRC versus Texas, but I'm thinking that would be more appropriate to save for the discussion panel time with the panel. Is my time up? Yeah. Well, I timed this, and I think my time should be up before. So anyway, I'm prepared to address those issues which may be crossing your minds as you have heard me speak. I think to sum up, I would say it is no exaggeration that these cases over the past 6 years breathe new life into the most vital aspects of our Constitution. Its structural assignment of powers to separate branches of government, and the fact that a Bill of Rights means what it says. In the Bill of Rights, what the promise was made by the framers of the Constitution to the American people was not even Congress can take this right away from you, much less a mere administrative agency. Hence the decision in Mr. Jarkis's case where the constitutional right to a jury trial, which he had all along, could no longer be taken away from him, as it has been for decades in the administrative agency adjudication world. Thank you.
Thank you for inviting me today, and thank you to Ms. Little for an excellent presentation of an extremely long list of cases, some of which I'll talk about today. But first of all, I want to thank you for inviting me, and I want to focus in today on drilling down about the case on regulatory commission's independence. And in regard to that, I do have to confess that although I've had a lot of jobs, I can't seem to keep one. I was also nominated to be the vice chair of the United States Civil Rights Commission, and I am an independent commissioner. But nothing, absolutely nothing that I say today has any relevance to my work as a commissioner on that commission. This is in my capacity as a professor and also as someone who has worked up and down Pennsylvania Avenue in the Senate and in the White House. And yes, I've also litigated for the Department of Justice. I've been writing about the separation of powers since 1996, my first law review article on the Federalist Papers. So we are living in an age that Ms. Little noted was quite a bit of change. She gave us a long list, and I agree with that entirely. I gave a lecture in London last year called The American Public Law Revolution. I've been teaching law for, 30, 40 years, and I have to say I had to throw out my statutory interpretation book and write a whole new one. I'm pretty sure administrative law folks have to do the same. We've had major changes in law in Loper Bright, reducing Chevron deference and elevating my field, statutory interpretation, to the fore. Major question cases, these are just the vanguard of the revolution. And we have a big part of that revolution coming up. And that is the case involving whether independent agencies are independent anymore. I want to actually drill down on what that means, because it means something to the public that it doesn't necessarily mean in the law. So I'm going to get kind of technical about that. By June, we will know, late June. We typically in the Academy think they decide all cases right at the end of June. We've seen some exceptions recently, so I can't really predict, but typically we think the end of June, early July. It's a very big case. It's a case that will require them to reverse, as Ms. Little said, Humphrey's executor, a decision in 1935. And to reverse a case requires a whole different set of consideration, a set of factors, which will add to the length of the opinion. I filed a brief in Slaughter. I intended it to be a brief for neither party, but I ran out of time, so I filed for Slaughter. But basically, I wanted to alert the court to a missing set of history at the founding and all the way up to the ICC, where Congress had in fact created multi-member commissions over a very long time, and even in 1790. And they did important things, and they lasted for a very long time. I can talk more about that in the question and answer period. But so Slaughter is about the Federal Trade Commission. President Trump fired a member of the FTC summarily for no reason. Of course, in Humphreys, FDR tried to summarily get rid of Mr. Humphreys. So all presidents of all parties, and yes, I have worked in the White House, they want to get rid of people if they don't like them. So this has come back, and the question is if the court is going to come out a different way than Humphreys. The statute, and this is the technical definition of independence, in FTC says any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office. Call that last list, there's a term of art, we use INM, an INM clause. That's the key question. Is that clause constitutional? From the Supreme Court's perspective, that's the legal definition of independence, even though I don't think it's the founder's definition of independence, and even though I don't think it's necessarily the public's definition of independence. So any commissioner who is protected from removal by such a clause is considered independent, as I would be on the Civil Rights Commission, but also the Nuclear Regulatory Commission. So your statute provides similarly, and I'm quoting, any member of the commission may be removed by the president for inefficiency, neglect of duty, or malfeasance in office. Put in other words, if the court strikes down the INM clause in the Trump versus Slaughter case, the INM clause in the NRC statute will be unconstitutional. Now, I'm going to say here, Ms. Little was a little bit more polite about this. I believe that the Supreme Court has already telegraphed it will overrule Humphreys. How it will reverse Humphreys is the big question among appellate and Supreme Court lawyers. So they've given strong signals in their shadow docket, or the interim docket, as Justice Kavanaugh prefers to call it, where in a stay case, they indicated in a case involving the NLRB, also independent commission, that there were strong reasons to believe that President Trump would succeed on the merits. It was a preliminary decision. And Justice Kagan, of course, said she was very upset because this was an extraordinary order since it had what I call pre-versed Humphreys. Before even reversing Humphreys, it suggested that Humphreys would be overruled. Now, even if the court reverses Humphreys, as they've telegraphed this in prior cases like SELA law, so no one who teaches this should be surprised. I still have colleagues who keep fighting SELA law and its history, but I think that's a loser. I think what you're going to see is that there will be a reversal, particularly with respect to the Federal Trade Commission. Now, how they reverse that is the subject of much contention. So one of the things that people don't understand is they hear in the public, well, independent, the NRC, it's not going to be independent. Does that mean we can have, political science? No, that's not what it means. I believe Congress has broad powers under the Necessary and Proper Clause to actually protect adjudicators, as they did at the founding in commissions, as well as protect other parties from conflicts of interest, which they did at the founding as well, to prevent the kinds of obvious conflicts that are taken care of to some extent by these INM clauses. So what I would say is, even if the INM clause goes away, it'll be severed. It just doesn't mean anything. The question will be the day after Trump versus Slaughter. Will the president use that power to eliminate adjudicators he does not like? Will the president use that power? And I say this, both Republican and Democrat. Would a Democrat president use that power to get rid of all of the people who are on the opposite side of the party? So one of the arguments I made in the brief was that multi-member commissions are really a different animal. They're constructed by virtue of their partisan balance as well as their tenure to surmount certain kinds of political problems. And that's embedded not only in the INM clause, but throughout the structure, just as you have it here with the NRC, where the president can't name more than a certain number of people of a particular party. And the question after Slaughter, these will be the new removal questions, will be whether those clauses are also unconstitutional. Thank you very much.
Good afternoon, everyone. Home stretch for the day. I'm sure it's been a long day for everyone. I'll start by saying that while I've presented here on a number of prior occasions, this is my first RIC where I'm no longer an NRC employee or attorney. So with that said, it follows that whatever I'll say here today doesn't reflect the views of the NRC or the United States, or for that matter, my soon-to-be new employer. And while I'll mention a few cases that I previously worked on for the NRC, everything I will mention today is part of the public domain now. In fact, I'll begin with a brief story about the last big thing I did at the NRC. And what I'm referring to here is the oral argument that I did before the DC Circuit last October in a case called Beyond Nuclear versus NRC. And that was a challenge to a rule that the NRC had issued codifying, for purposes of the National Environmental Policy Act, the impacts of renewing an operating license for nuclear power plants. The challenge related specifically to the way that the NRC had evaluated risks associated with aging equipment and climate change in identifying the potential impacts of a nuclear accident. The petitioners there argued that the accident analyses performed for purposes of NEPA didn't properly account for these variables. By contrast, the NRC believed that its conclusions, backed by its safety analysis and its regulatory oversight, was more than sufficiently robust to determine that the probability-weighted impacts of a nuclear accident were small. Now, a bit of context here. We'd filed our brief in the case about a year ago, back in early 2025, before the Supreme Court had issued its decision in 7-county infrastructure. And once that decision came down, and I suspect most of you are familiar with it, and as we were awaiting oral argument before the DC Circuit, we filed what's known as a Rule 28J letter with the court, advising it that there was new significant authority relating to the case. But by rule, our letter was limited to 350 words, which obviously isn't a lot of room to work with to bring to the attention a major development in the world of NEPA. And we wanted to draw the court's attention specifically to Justice Kavanaugh's discussion about how agencies should be given wide discretion in identifying how and to what extent environmental impact should be incorporated into their decision-making process, and Justice Kavanaugh's statement that judicial review of NEPA could be summed up in one word: deference. So because this was such an important point for the government, and because we hadn't had much opportunity to discuss the case, that was what I led with at oral argument. And I said at the very beginning of the argument, with all the confidence of someone who thought that 7 County was my ace in the hole, I said, under 7 County, an agency is entitled to deference not only with respect to its technical determinations, but also in determining what types of information will meaningfully inform its decision-making process. But here's the rub, and this is the reason I'm telling the story. I barely had gotten those words out of my mouth when Judge Millett, one of the judges on the panel, immediately responded and said, I get that deference, and the but consisted of about 20 minutes of challenging and at times uncomfortable questions directed at me, getting to the completeness of the NRC's examination of accident scenarios, whether the agency in fact had a basis for determining that there was adequate margin supporting its accident analysis, and whether the agency could simply rely on its ongoing oversight processes to ensure that the probability-weighted impacts of an accident were small. And the questions were particularly poignant at the time because at that precise moment, a major hurricane was bearing down on South Florida, and it was important for Judge Millett to understand that the agency's professed ability to respond in real time to events associated with climate change had a basis in fact. So the point I'm getting to is that deference is a helpful starting point, and one that courts will undoubtedly acknowledge in a post-7 county world. But like Judge Millett, judges are going to want more. The NRC is going to have to justify its decision-making, and here I'm not just talking about NEPA, but also its efforts to introduce new regulations through rulemaking with more than just a reflexive incantation of the standard of review or the comprehensiveness of its regulatory programs. And while everyone in this room, I think, is cognizant of the fact that there's a push from both Congress and the administration to increase the amount of electricity being generated from nuclear power and to get new sources of power online as quickly as possible, adopting the attitude that the regulatory process is an impediment to the issuance of licenses may have the result of delaying rather than expediting any kind of nuclear renaissance. As someone who's sat in the hot seat on a number of occasions defending the NRC, I can tell you that the agency gets a great deal of mileage in court through its ability to say that it has been thorough and fair in its evaluations, that it's transparent with the public in its communications and its release of information, and that it offers the public a meaningful opportunity to participate in decisions that are very important to communities in and around nuclear facilities. The court's willingness to trust the NRC's assurances that things will be safe is directly related to the agency's transparency, and it's a commitment to the idea that no licensing decision is foreordained. So where is the agency most likely to get deference when it issues rules or performs environmental analyses? Certainly in its technical judgments and even its adoption of risk-informed decision-making. Quite famously, the Supreme Court stated in Baltimore Gas and Electric that judges should remember that this agency operates at the forefront of science. There's a built-in reluctance from which the agency has benefited greatly in court for lay judges to second-guess the technical determinations of the highly qualified experts at White Flint and in the regions. But again, deference doesn't mean blind faith. The agency needs to show its work, and I can attest to this through years of litigating cases like Shield Alloy, for those who remember it, and the New York v. NRC cases in the DC Circuit. We didn't win those cases on the first try, because the agency in the court's judgments skipped a few steps, even though the agency believed, just like it does today, that it had all its ducks in a row. The court simply expected more from us. The agency is also likely to get deference when it invokes its own historical experiences in overseeing the licensing and oversight process and makes judgments on the basis of these experiences. This certainly is relevant to the agency's ongoing reconfiguration of Part 2. How long should parties be afforded an opportunity to respond and raise contentions concerning a license application? What form of hearing is best suited to enable litigants to be heard in an efficient manner that is designed to get to the bottom of legal or factual issues? It will be hard to say, I think, in the abstract, that rules that the agency has proposed seeking to expedite the hearing process aren't the product of wisdom acquired through 50 years of hearings. And I think courts will be receptive to that expertise, as they have in prior cases when the agency has overhauled its hearing procedures. But I think the agency also needs to be prepared not only for a facial challenge to Part 2, but for an as-applied challenge that asserts that a focus on time above all other considerations could ultimately deprive litigants of their statutory right to a hearing. It's true that the courts applying Chevron ruled in the 1990s and 2000s that the lack of a specific definition of the term hearing in Section 189A of the AEA provides the agency wide discretion in putting meat on the statutory bones. But expediting hearings solely for the sake of getting technology licensed faster may be viewed with something of a jaundiced eye. And I would note that the courts may be particularly receptive to arguments when they're presented with reference to concrete examples that potential interveners weren't on notice of the existence of a factual issue that was buried in a license application, and that a reasonable person starting from scratch would have been hard-pressed to discover in a very limited period of time. I think the problem may be even more acute if it's perceived that the proposed rules incentivize license applicants to bury or exclude controversial information. Anyone who listened or attended the Supreme Court arguments this past year in NRC Texas will recognize that justices from across the political spectrum were concerned about the fairness of shutting people out of the hearing process. And I think the agency should be sensitive to that reality. So I don't want to suggest in any way that the agency will get a free pass as it rewrites its rules. And in many ways, I want to note that there are storm clouds on the horizon, much in the way that for years lawyers saw storm clouds on the horizon every time they cited Chevron or Auer, both of which have now been dialed back or confined to the scrap bin of history. For years, the agency cited to the D.C. Circuit's language in Siegel versus Atomic Energy Commission, which talks about how the Atomic Energy Act is virtually unique in the way that Congress has foisted broad responsibility upon an administrative agency, free of close prescription as to how it should achieve its statutory objectives. We used to cite that principle like a wind-up doll as a reason to defer to the agency. And a little story I'll tell in that regard is that I've abandoned this, but my password to get into Pacer used to be deference, ! It means that the agency gets this, the Siegel principle means that the agency gets to structure its proceedings and its methods for licensing in the way that it wants, without a lot of interference from the courts. And that conclusion underscores a lot of what I previously said about deference and the NRC's chances of successfully defending its current rulemaking efforts. But if you read Justice Gorsuch's concurrence in the Supreme Court's recent decision concerning tariffs in learning and resources versus Trump, it also puts the agency's wide discretion in the crosshairs of a muscular major questions doctrine or even a revived non-delegation doctrine. Agency power is not unlimited, and the courts may push back if a grant of authority is too broad or too vague, and if what the agency has done doesn't fit relatively snugly into Congress's directives. And to some extent, this is exactly what the situation we faced in NRC versus Texas, which the agency ultimately prevailed on, but only on the procedural side of the case, and specifically the petitioner's failure there to become parties to the adjudication before the agency, and thus their inability to challenge the NRC's licensing decision in federal court. That case was a major component of my work at the NRC for 4 years and the subject of a number of my prior RIC presentations. And if I can reflect back on that case now that it's over, what the merits issue boiled down to there was a legal interpretation largely arrived at a time when courts looked more generously than they do now on the expansive exercise of broad governmental authority. If you recall, the agency promulgated Part 72 of its regulations in 1980, relying on a broad delegation of authority to use materials licenses, even though the Atomic Energy Act didn't specifically mention spent nuclear fuel or the storage of spent fuel, and even though the Nuclear Waste Policy Act, enacted after Part 72 was promulgated, included at least some language that could have been construed to have spoken more specifically to the issue of fuel storage and arguably directed that interim fuel storage be confined to either a federal repository or a federal MRS or to on-site storage. And so the NRC achieved victories in the Bull Creek case before the D.C. Circuit, and the Supreme Court signed off, albeit in dicta, on the NRC's conception of its legal authority to license spent fuel storage in Pacific Gas and Electric. In those cases, the courts accepted the idea that the NRC's authority to issue licenses for special nuclear material for such purposes as the Commission determines will further the purpose of the Atomic Energy Act, as set forth in Section 53 of the AEA, authorizes the agency to license the away from reactor storage of spent fuel. In fact, there really wasn't any question at the time that the AEA should be read broadly enough to include this authority. For all the reasons that we explained in the litany of briefs that were filed in these cases at the D.C. Circuit, the Fifth Circuit, the 10th Circuit, and the Supreme Court, the agency had and has ample justification for licensing the storage of spent fuel away from reactor sites. But if we go to the text of the Federal Register Notice where Part 72 is promulgated, it's not easy to find an explanation for the Commission's adoption of Part 72 that would satisfy Justice Gorsuch's muscular version or muscular interpretation of the major questions doctrine as he articulated last month in Learning and Resources. The same principles underlying his concurrence in that case fueled his observation on the merits in the NRC versus Texas case, even if it turned out, along with the majority's response disagreeing with him, to be irrelevant to the ultimate outcome there. Justice Gorsuch and two colleagues didn't agree that the Commission's authority to issue materials license for industrial use or for uses that the Commission determines will advance the purpose of the AEA should be read broadly. To Justice Gorsuch and at least two other members of the Court, explicit authorization rather than implied authorization through broad grants of authority is required before the agency enters into new terrain. And obviously, new terrain is where we're headed today. And maybe looking back on the NRC v. Texas case, it's just another in the long litany of cases about NIMBYism, and no further explanation is warranted. But if we can learn anything going forward from this experience, I think it's fair to say that when the NRC or the industry, what the NRC thinks or the industry thinks is obvious about the AEA might not be as obvious as we all thought, particularly if what we thought of as a long-standing established principle of law was decided in an era when Chevron provided the framework for resolving issues of statutory interpretation. And I recognize that in Loper Bright, the Supreme Court said that interpretations decided under the Chevron framework remain good law. That's true, but they remain good law until a court determines that a particular reading, although perhaps reasonable, isn't the best one. In the meantime, I think the agency would be well advised as it moves forward with new regulations that rely on the broad grants of authority that the AEA provides, to tie its rulemaking efforts directly to statutory text and to make clear for reviewing courts exactly why it is determining that the rules it is promulgating fit within the statutory scheme that it has been given broad discretion to manage. Thank you.
Good afternoon. It's a privilege for me to join this panel to address some remarks. You know, I'm the generalist in the room. I did not work in an administrative agency. I certainly didn't work in the nuclear regulatory field. I was a judge for 25 years. I never understood Chevron deference, and now I won't have to understand it either. You know, I think back to statements in cases that said it's the unflagging obligation of the courts to decide what the law is. But then you had Chevron that said, but you have to defer to administrative agencies when they say what the law is. It made a lot of sense because of the technical expertise that agencies have. On the other hand, when it was a question of statutory interpretation, who's a better expert than the judge? Would be my argument. So you're all going to have to adjust to this new landscape. The NRC has found itself at the center of major shifts in administrative law, in federalism, and national energy policy. Loper Bright is the case for me that is the most significant change, because it said that when interpreting statutes, courts no longer need to defer to the administrative agency's reasonable interpretation of that statute. The courts now decide what the statute really means. Courts will now independently interpret the Atomic Energy Act, the Nuclear Waste Policy Act, and related statutes without deferring to the NRC's technical expertise. This imposes increased litigation risk and reduces predictability for licensees. The NRC must now justify its regulatory decisions through textualist statutory interpretation, not technical policy reasoning alone. And without Chevron, different courts may reach, and they typically do, reach divergent interpretations of NRC authority, creating uncertainty for national nuclear deployment. The NRC regulates highly technical, safety-critical systems. Historically, courts recognized that agencies like the NRC possess the unique scientific expertise. But Loper Bright shifts interpretive power away from that expertise and towards generalist judges, raising the stakes for every rulemaking procedure, every guidance document, and every licensing decision. I think what you'll see is more aggressive state challenges to NRC rulemaking. You saw that in NRC versus Texas, while the court upheld the NRC's regulation of interim storage partners' proposed facility. The court did signal that there can be more aggressive state challenges that might be successful. And you'll have to deal with these challenges dealing with the small modular reactors, or SMRs, and microreactors, with arguments that the NRC is exceeding the statutory limits of its authority. Courts now will be more willing to revisit longstanding agency interpretations. And even though the NRC prevailed in the NRC versus Texas case, the court's reasoning reflects the post-Chevron environment. Statutory text controls and agency interpretation receives no special deference. Every major NRC licensing action, especially for advanced reactors and fuel cycle facilities, may now face state-led challenges. Recent executive orders have emphasized accelerating domestic energy production, streamlining permitting, and reducing regulatory burdens. While these directives aim to promote nuclear deployment, they create challenges for the NRC. First, there's the pressure to accelerate licensing timelines. Executive directives encouraging rapid deployment of advanced reactors place the NRC under scrutiny to speed up its processes without compromising safety. There's increased oversight of agency rulemaking, new requirements for cost-benefit analysis, retrospective review of regulations, as you see going on right now, and justification of major rules increase the procedural burden on the NRC. The NRC's statutory mission prioritizes safety. Executive orders emphasizing deregulation can create conflicting expectations, especially in areas like environmental review under NEPA, emergency preparedness requirements, and cybersecurity and physical security standards. Implementing new executive mandates while responding to increased litigation, which I think you'll see, and rulemaking demands will strain the NRC staff capacity. Emerging challenges for the NRC, with states increasingly challenging the NRC authority, the agency must navigate inconsistent judicial interpretations, state-level bans or moratoria, and political resistance to federal citing decisions. Post-Chevron, the NRC must translate technical judgments into textual statutory arguments, requiring new legal strategies and closer collaboration between engineers and attorneys. High-profile litigation and political conflict risk undermining public confidence in nuclear safety oversight. As courts narrow agency discretion, Congress may need to amend the Atomic Energy Act or the Nuclear Waste Policy Act to clarify NRC authority, an uncertain prospect, of course, in this polarized environment. So the NRC stands at a pivotal moment. The combination of Supreme Court decisions, state-led challenges, and executive directives has reshaped the regulatory environment more dramatically than at any time in the last 40 years. To meet these challenges, the NRC must strengthen its foundation, enhance transparency, and adapt its regulatory processes while remaining steadfast in its mission to ensure the safe use of nuclear material. Thank you very much.
All right, let's go ahead and move to questions, and we have a number from folks out in the audience as well as from online. I would remind you, there's a QR code up there. If you want to send us a question, you should certainly do so. Online, you can do it through the online app, and here in the room, if the QR code's up, you can certainly take a shot with your camera and send us a question. So let's start off with a question for Peggy Little. You mentioned the Lucia case and the appointment of administrative law judges and their independence. I don't mean to make Chief Judge Hawkins uncomfortable, but how might that apply to judges on the Atomic Safety and Licensing Board panel with the NRC? And just by way of background, I should tell you that Section 191 of the Atomic Energy Act sets up the panel. It allows the Commission to appoint members. They've now been given the term administrative judges. We're not administrative law judges, although there have been administrative law judges on the panel in the past. And we're appointed by the Commission, who are obviously go through the advise and consent process with the Senate.
I think you're fine. The SEC, shockingly, had not had a head of a department, which is what the Constitution requires, appoint these judges, which had been deciding cases for decades. And when that came to light in a case called Timber something, the SEC actually produced phonied up, thank goodness not sworn statements, suggesting that, well, they were appointed. Well, they were not. And these kinds of formalities are important in our public life. If the Constitution requires appointment, it needs to be made. And that's why over 100 cases got vacated. And that's the only holding of Lucia. So I think you're fine, as long as the head of department appointed them. Now, the removal question's a little tougher. And as I said, Celia Law and Collins talk about that, but there really has not been a case where remedy has been offered for an ALJ based upon multiple layers of removal protection. So that is yet to be decided.
Any other panel members have anything they want to say on that subject?
I agree.
All right. This one, let's have a question for, we have a question for Victoria Norris. You talked a lot about the presidential power and separation of powers. How do you see executive orders like Executive Order 14300, which was mentioned at the beginning, in terms of legality or illegality?
Well, I'll just say generally, I'm a generalist here as well, that executive orders can't, unless the president has a foreign affairs power, if it's in the domestic sphere, he's at its height of power when he is acting consistently with Congress. So if the executive order says something that's unconstitutional, or if the executive order says something that is contrary to what Congress has said, it will be easily subject to challenge, and there have been a number of orders. I'll just give you a quick example. The president has said that he can make an executive order about elections. Well, the text of the Constitution, has this delegated expressly to the states. So you can't just say it's an executive order. You have to decide whether it's consistent with the Article 2 power and consistent with the stanute.
All right, thank you. A question for Andrew Averbach, and actually Judge Van Ansky sort of raised this. What do you see as the future for state authority relative to nuclear materials and nuclear reactors. I know there's been at least one case down in Texas that raised this question about the state of the authority of the state of Texas or other states to regulate some aspects of nuclear power under the Atomic Energy Act. Do you have any thoughts about that?
I think that the question of preemption is one that I've wrestled with for the entirety of the time I was at the NRC, and it continues to be an issue. I think that if this nuclear renaissance takes off, I think that you will see more states who perhaps are more concerned about some of the facilities that are constructed, and it will be a fertile ground for litigation going forward. You know, the agency did not prevail in the Virginia uranium case. And it's true that the Supreme Court took a narrow review of preemption there, but preemption arguments still survive Virginia uranium, particularly to the extent that the state law or municipal regulation or whatever it is at issue regulates something that the NRC itself directly regulates. Just recently, the District Court in Southern District of New York issued an opinion deeming preempted a New York State statute that purported to ban the disposal of waste from the Indian Point Power Plant into the Hudson River, even though that conduct was sanctioned by the NRC license. That case is now on appeal to the Second Circuit, and I think it's probably likely to be affirmed on appeal. And I think that preemption cases are likely to be filed. I think that there are going to be a significant number of them on which the licensees prevail over the states. So I think that's something to look out for in the future.
All right, thank you. Any other panel members have anything? Judge Vanansky, based on what Andrew said, any other comments you have on that subject?
I have no other comments.
Well, Judge Vanansky, let me pose a question to you. You talked about post-Loper Bright, obviously the authority given to courts to interpret agency statutes and regulations. As you pointed out, there's a lot of very technical terms in the Atomic Energy Act, and the agency has provided various definitions of the terms like source material, byproduct material, things like that. How does a judge, when those issues are now put before them in terms of agency interpretations of very complex or maybe a little bit unclear statutory terms, how are you going to deal with that as a practical matter?
Well, as a practical matter, you deal with it as you would any question of interpretation, complex contract provision, complex regulatory provision, complex statutory provision. You use your basic canons of interpretation, and you look to the plain meaning of if there's no plain meaning, then you dig deeper. But one thing you're not going to do is defer to the agency's interpretation just because the agency said it so. The agency can be persuasive, and there might be a basis for Skidmore deference, but the point is the court has made clear, I think, that when it comes to a question of law, it doesn't matter how complex the subject matter is. The courts must determine what the law is.
Could I add something to that? I entirely agree with the judge's statement about Loper Bright, but of course that is my field, you know. And I think you cannot rely on deference. I think our deference is dead. I think Skidmore is dead as such. I think if you don't have the best meaning of the statute to start out with, you're in trouble. But when it comes to technical terms, some of us teach the difference between ordinary meaning, which the court always invokes, if it's a statute directed to ordinary people, like homicide. But if it is a highly technical statute, there are times even this court has said, I will embrace a technical meaning, so in your briefs, you better be ready to explain that. So Justice Barrett, in a case involving computers recently, sought to define the term access to computer by how we technical people think of that term. And I think the judge would, I hope, would agree with me.
Yeah, I absolutely agree with you. And that's a great example of that decision because, we can think of access to a computer as straightforward, but it's not necessarily straightforward.
I'll just jump in here real quick. Professor Nurse, you mentioned our deference and you think it's gone. I know it was recently upheld. Do you think that, and by a lot of members of the current court, what makes you think that if that comes up again, it's going to be treated differently this time?
I think there are lots of people litigating in Washington who have reasons to bring these cases to the court in a more friendly situation than that case you're talking about. There are a number of members on the court who are vying for Justice Scalia's mantle as the best textualist, and I see them as being philosophically hostile to this.
Right. Let me come back to Peggy Little. You talked about the Jarkissi case. Under the NRC's enforcement regulations, the agency does have the authority to issue enforcement actions, orders that would ban someone who works in the nuclear industry from pursuing that job for a period of years, say 3, 4, 5 years, if they violate some of the Atomic Energy Act sections. Question: do those then? There's some thoughts that whether those should or shouldn't be in a jury trial in federal district court, as opposed before administrative law judges.
My response on that is any kind of reputational ban or bar should be in an Article III court. And I think the thought that, the sky's going to fall if you have to go before a judge who is independent, and that was another word used in Jarkissi, is a false fear. No one, whether you're the person who's about to be sanctioned or the NRC or any agency, should be afraid of an independent judge. That's what the Constitution means when it puts the judicial power in a separate branch of government. And I think what has become the default mode in too many agency prosecutions of doing it before the agency, where they are investigator, judge, prosecutor, jury, and final arbiter of that matter, is deeply troubling. And I think the reputational damage would suffice to get you in there. Now, I'm not so sure about the jury trial. I'd have to think about that in terms of just the industry bar. But these are lifetime, life-ruining, very harsh and consequential matters to the person under the prosecution. I think there's no good reason at all why they shouldn't be in a federal court before an independent judge.
And let me see, Andrew Averback, do you have any thoughts about the impact of Jarkissi on NRC enforcement actions?
A couple thoughts. I don't necessarily think that the NRC's scheme fits as closely into the sort of paradigm of common law fraud as what was at issue in Jarkissi. So it's not entirely clear to me that whole framework applies to what is obviously not something that the founders envisioned in 1789, whether or not the NRC should somehow have the authority to take action against the licensee. So I don't think it's anything, because it's a creature of common law, and the name of the case that's escaping me that dealt with OSHA sort of kept open for another day the possibility that it kept open the possibility that there would be statutory schemes that aren't close analogs to common law fraud or the like, for which a jury trial was available at common law.
The case is Atlas Roofing, right. And I think that on its facts should be overturned. Now, I did reserve the issue of a jury trial right. I haven't thought that through, and I have not studied the NRC statutes. So if there's a case to be made that the action to be taken against the licensee is not covered by the 1789 definition of what gets a jury trial, that's a separate question. Because there are two holdings in jarcossy, and that's very important to remember. And the first one is you have a right when the government is taking a property right from you or seeking monetary damages to be in an Article III independent federal court. And the reputational damage is largely seen as a property right in Anglo-American law. So I still think you belong in an Article III court, and I'd really need to study the scheme with, I really am a generalist here, to answer the jury trial question.
Any other thoughts from the panel on jarcossy? Anyone? And I should mention, feel free to jump in once if another panelist has a response you want to talk about. This question for Victoria Norris, I think you made a passing reference to the non-delegation doctrine. That was sort of very up in front and center for a while, and it seems to have sort of gone to the background. But where do you see that things are with the non-delegation doctrine at this point?
Well, I think that the court has operationalized the non-delegation doctrine in the major questions doctrine, and perhaps in their future decision in Trump versus Slaughter, and this is Justice Kavanaugh's position. So they have they've gone back to the intelligible principle argument. So if the statute says in the public interest, and there's some intelligible principle in the rest of the statute to explain what the public interest is, that should be sufficient under the recent decisions, which suggest that the non-delegation doctrine doesn't exist. But Justice Kavanaugh said in a concurrence that, well, actually, we've done the work of that in the major questions doctrine, and that major questions was really an operationalization of non-delegation. Because Justice Gorsuch proposed a test, and no one could quite figure out, who's doing the details. No one could quite figure out how to do it. Sometimes courts refuse to adopt doctrines, as I expect the judge knows, when they just can't figure out its limits, or how to actually apply it is just as important. So they never got around to that. Right now, they are implementing it through major questions. And Justice Kavanaugh indicated he thought that Justice Gorsuch's concerns would be allayed, because Justice Gorsuch is the main leader on non-delegation and major questions. He thought they would be further allayed if we got rid of independent agencies, further telegraphing that they will, in fact, overturn Humphrey's executor.
I would add, too, that fits in, I think, with what I was trying to say, perhaps you said it better, about the concurrence from Justice Gorsuch in the Learning and Resources case, where he basically used the same themes to say, whoa, this is too much for the legislature to be delegating to an agency. And you can call it non-delegation, you can call it whatever you want, but it's a problem if the agency is doing more than Congress permitted it to do.
One way that my organization likes to conceive these issues is, and there's an article on this for any of you who are interested in delegation, written by Philip Hamburger, called Non-Delegation Blues. And one of the points is when you frame a question in terms of delegation, there's a lot of baggage that comes with that, and the outcomes are not particularly easy to reconcile. And in fact, in the recent case of Gundy, the court came within a hair's breadth of revitalizing the non-delegation doctrine. I think that was in the 2019 or 2020, I can't remember. So it's not a dead doctrine, but it's an unsatisfactory doctrine. And I would suggest to any of you practicing in this area to consider a different concept. And this was included in the Gundy decision. And that's and highlighted by Justice Gorsuch. And that's vesting. The question is not so much delegation, but where's the power vested? And if it is vested, as it is in Article 1, exclusively, the lawmaking power exclusively vested in Congress, that can answer non-delegation question in a far swifter and more satisfactory way. So I do throw that concept out there as a way to think about these problems.
I'll just add, too, that there are times when that makes a lot of sense, and then there are times when you come to this conference and you think to yourself, there's no way that Congress is going to be able to make laws to govern the construction of advanced reactors. And I have thought to myself, and this is kind of what I was getting at when I mentioned the Siegel case, that Congress recognized way back when that maybe there's a subcategory of agencies that are just too darn complicated for Congress to start overruling or to start legislating in, or for courts to start overruling the agency in. And part of me wonders whether a lot of the discussion of independence or things like that could result in some kind of doctrine where super duper technical agencies, for which this is, I think, is the best example,
Right.
somehow get more deference than something like, I don't know, the FTC or the NLRB, which judges might be a little more reluctant to overturn the decisions of.
Can I just add one thing? I think that I know everybody loves to hate Congress, but I actually worked there when we actually passed bills. And I worked in the Senate, even. We had to get to 60, but we still passed bills. And I worked on the 1994 crime bill. So I would urge you all to consider it may actually be possible in this current world where, and the only reason I know this is my husband's worked on the National Academy with modular reactors, but there is a kind of bipartisan moment, perhaps, on nuclear power where this is a time not to be afraid of going up to Congress. They don't bite. They want issues to actually legislate on.
If I could just raise a little bit of a follow-up, and this kind of goes back a little bit to deference issues, talking about super-duper technical agencies, which I would love to have on a business card. Exactly. So even if we find ourselves in that situation, or if we find ourselves in the situation, Professor Nurse and Judge Van Aske, you were talking about how courts will still, with technical terms, sometimes give deference to, small d deference to the interpretation of a term or a term of art to an agency. One of the questions that I posed in the introduction was, what do we see as a possible impact of the OIRA review process on whether courts would still be willing to give that small d deference when it comes to regulations that have gone through that OIRA review process? And that's for anybody who wants to answer that one.
Well, I'll answer off the top of my head that I think in those circumstances, there will be deference, small d, given to that technical interpretation. As a judge, you would look to see, well, what's the consensus out there? What's the consensus view on the agency's interpretation? What are the criticisms of it? Those are the types of things that you would take into account in terms of making a decision. And there are going to be, deference is not dead yet, but it's not going to be like it has been. That's a very broad statement, but I think that captures it.
To that, I would add, I was delighted that Professor Nurse brought up Congress, which has been notably absent from a lot of these discussions, and it should never be. That's where the lawmaking power is made. And I would pose the question this way: do we really want to be entering a new time of employing nuclear power in these small generators and a lot of other technical things I'm really not qualified to describe, much less talk about? Do we really want to be regulating those under a 1954 statute that was amended in '82? Or do we want Congress to get together and do its job and talk about how we adopt these things that solves the preemption problem, it solves a lot of state objection problems, and it also means that rather than a court giving deference to what they think may be some sort of agency expertise, which may or may not be actual expertise, Congress, which is equipped to hold hearings, hear from all different kinds of nuclear scientists and safety experts and sabotage experts and cyber safety experts and all of these things, can try to put these, revive a nuclear industry, which is desperately needed, but do so with some clear guidance about what the laws need to be under an entirely new factual, legal, you know, the effects of the internet and cybersecurity are enormous. I think we just need to legislate rather than try to defer, talk about delegation of acts that were plainly did not have any of these things in mind when they were passed.
This question, talking about Congress and its bringing it up and possibly related to it not really interjecting itself much lately. There was a question directed to Professor Norse, but I'll open it to the rest of the panel as well. The question came in, with a Congress that defers to the president, what is the likelihood that executive orders will be challenged? And I think it goes, Professor Norse, to your talk where you were talking about how executive orders that generally conflict with statutory enactments tend to be more likely to be challenged, but what is the likelihood of that challenge when you've got a Congress that seems to be willing to defer?
Well, I mean, yes, they're all unified by party right now, but private parties who can claim injury can bring a lawsuit. So, for example, I was just looking at, there's a statute that says that when you want to build a monument, you have to kind of go through some processes, and someone's challenging the various monuments that the current president wants to build. Now, I think, you know, the larger point here is that I think that what the president often does, and other presidents have done this as well, they're communicating what they think the law should be, right? So they're trying to communicate to the public and create a political issue, in essence, when they say these things, that Congress might then legislate on. They may or they may not. And I will say to you that they just passed a piece of law, or they're about to pass, on housing. Yes, they've passed fewer laws than they ever have. On the other hand, when you get we are in a very polarized, geographically, politically. There are issues where everybody says, yeah, we need some AI regulation, right? And we need some, so they get together and they try to figure out ways in which they can achieve that and update old laws and things like that. So I don't think you should assume at the start that they can't do things before you actually try.
I'll raise one point that may or may not be relevant to this question. But when we're thinking about Part 2, and we're thinking about the rewriting of Part 2, and you look at the proposed rule, certainly the reason that the agency is doing this, it becomes clear, is largely because of the executive orders, and largely to fit within the timeframes mandated by the executive orders. And I understand that that's a perfectly legitimate reason for the agency to want to do what it's doing. But if I'm writing the brief defending the government a year from now or whenever it's going to be, I don't want to rely on the idea that we're doing this and it's legal because it was part of the executive order. That to me is why you did it, but not a legal justification for doing so. And I think that people need to understand that an executive order doesn't have the force of law in and of itself, absent the sort of foreign affairs context you're talking about.
The statute controls. The statute controls. So if the statute allows you to do that, then you're good.
Right. And, the agency can put forth a basis as to why it's rewriting Part 2, why it thinks that this is not an arbitrary and capricious scheme that it's creating, and all those reasons should be in the government's brief. But I don't think oh, because the president said we should do it and needed to do it, is going to sway too many on the courts.
Right? We talked a little bit before about the states and their regulatory authority or their potential opportunities to take more under their wing under the Atomic Energy Act. There's another player here, however, the Department of Energy. And maybe, Andrew, do you have any thoughts about will DOE inherit more regulatory purview over segments of the industry that are textually unexplicit in the Energy Reorganization Act, but broadly covered under the AEA? Such as in the processing area? What is DOE's role here? So I guess the overall question is, what is DOE's role here in terms of regulation under the Atomic Energy Act? Obviously, the AEC was split off but is that changed in some way?
I don't know. And one of the questions I was thinking about today that perhaps someone might have asked was, well, you say that these major question type issues might be a problem for the agency. Where is that? Where might that come up? And one of the things I thought of in advance was, well, DOE has, and the Department of Defense, War, whatever the name is, have certain statutory authorities to carry out a limited set of functions vis-a-vis nuclear reactors, and that's what's going on pursuant to the executive orders. Perhaps there's a point when the tail starts wagging the dog and the NRC is relegated to a place where it's not performing the primary function of regulating commercial nuclear reactors. And that concerns me because I think that starts to be inconsistent with the scheme that you're talking about that Congress created.
I'm going to read this question directly, Professor Norris, and let you run with it however you want to. If Humphrey is overturned, how might the court structure the remedy? Independent agencies were often granted wide powers by Congress under the assumption that Humphrey's executive was good law and that the independence of the appointees would constrict or check the otherwise broad grant of power. Does the court have any option in reversing Humphrey's other than keeping the grant of power to the agency without restrictions?
Okay, the first part is the remedy, and that there's a doctrine called severance, which we deal with a lot. So what will happen, and I know that Ms. White must know about this since she knows these cases. So there's different views on severance, but in generally the easiest remedy here is just to essentially say the INM clause is unconstitutional and not operative. It is unconstitutional, so the president, and then the question is what the president does after that, right? How far the president moves from that decision. The court could explain a little bit more about the remedy. Maybe somebody else on the panel would know about that. They have sparred some about this kind of remedy, but you also asked about agencies with lots of power. So yes, agencies have lots of power. They have power whether they're independent or whether they have those INM clauses or not. DOA has enormous power, right? So I think independent agencies have gotten a rap that they're a fourth branch of government and that they have super duper powers. But if you look at them relative to departments, it's not clear to me that that's true. My agency just writes reports for Congress, right? We have no power to do anything to a human being. We can subpoena some documents, but that's pretty much it.
I'd be curious if you have any thoughts as to whether, and I think you kind of suggested that, well, if then so too does all the agency independence. Likewise, should all the independence of all the agencies fall? I'm wondering if you see any effort or possibility that different agencies may be able to say, hey, we're not like the FTC, either structurally or because of the subject matter we regulate or anything like that.
Yes, I think there's going to be a lot of litigation, depending on how the case is written. There'll be more rather than less. But agencies, what people don't understand about independent agencies, it's because Congress negotiates them out in various different ways, and they look very, very, very different. So in the case of my agency, a former president who was then a senator negotiated this when Marion Francis Berry got into a fight with Ronald Reagan, and its statute looks nothing like any other independent agency. And so there is an argument by Republican members of my commission that, in fact, we exert no executive power, so that we're just a one-off, right? Because all we do is write reports for Congress. But there'll be litigation about it, I expect, and that's just one simple example I know well, and we've debated it. But there are going to be challenges in other independent agencies that they don't look, and this will, I know the reason that the opinion is taking longer is because they now have to think about that. They've already indicated they're going to exempt the Federal Reserve. And there are some, the only reason I can say that that works is because there was the first and second Bank of the United States, and then there's something called the Sinking Fund, in which was the most important multi-member commission in the founding. If it didn't exist, we wouldn't be here. It existed for 40 years, and it bought debt from foreign powers who would have otherwise conquered the United States. So I think that there's going to be a lot of contention about what other kinds of agencies, and even within the agencies. So they may say, FTC, you can't do executive power, but maybe there might be, Chief Justice Roberts suggested there's a case called Wiener that might support multi-member commissions that engage in adjudication, essentially. They're claims commissions, which do go back to 1790. So there may be an exception for that. I can't predict that at this point, but there will be litigation.
Thank you very much to our panel for your excellent participation in the Q&A session. We really appreciate it.
I want to thank the audience, both those of you here in person and those who are watching remotely, for your attention and for the thoughtful questions. I especially want to thank our distinguished panel for sharing their thoughts and perspective on this timely subject. Time will tell the ultimate direction administrative law will take and how independent administrative agencies regulate matters under their jurisdiction. It is certain that the Advance Act, Executive Order 14300, judicial decisions like the ones discussed today, and the NRC's recently proposed revisions to its adjudicatory procedures will change the way the NRC processes applications that come before it and the procedures that the ASLBP will use in its adjudications, and ultimately how the courts apply deference post-Loper Bright. Your feedback's important to us. Let us know what you thought about the RIC in general and this session in particular. Your insights will help us shape next year's program. You can provide feedback through the platform by selecting the feedback tab in the session or by accessing the link from the RIC website. For those of you who like to plan ahead, next year's RIC, the 29th Annual Regulatory Information Conference, will be held March 9th through the 11th, 2027. Thank you all, and we stand adjourned.